Kaufman, you may address the court.
Thank you very much, Your Honours. Now, before I start, I would like to make one general comment, and it's a comment which every defence counsel who appears before this court is obliged to make. So, if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defence's submissions, I hope that they will at least communicate the following faithfully. The defence does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be levelled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defence's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defence's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defence's role is simply to persuade Your Honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So that police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, Arrest them if you can. But if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, "Just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it." Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this, "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had the speech of 2 pages prepared, but to his regret it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument, because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to bruise the prosecution on the matter is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory with respect to the definition of the targeted population is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting 2 alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pre-trial chamber in the El Hishri case. And I do apologize in advance for the rather dull exposé which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pre-trial chamber, this same pre-trial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pre-trial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely The second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purpose of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defence has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte, or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was in addition wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee: at least more or less than 10 buy-bust operations. Where somebody was shot? Asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee: yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress, to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated, and that is set out in paragraph 27, and mentions that on the very day that the former president appointed Ronald de la Rosa as the chief of Philippine National Police, de la Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralisation of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralisation as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralisation forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald de la Rosa, Bateau, within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, de la Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that de la Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Kaufman, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that would be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.